Just a minute. Yes.
My name is Israel. I appear alongside Kiplagat. Good morning, Donna.
Good morning.
So the respondent, we are ready to take the
Good morning, Anna.
Good morning.
My name is Lisa.
So in this case, the respondent was brought to court by the notice of motion application, which was dated the 24th of June, 2026, seeking inter alia that the respondent be conveyed out of Kenya and surrendered to the UK to face multiple charges, amongst them murder. When he was presented in court on the 26th of June, 2026, his advocates prayed for the respondent to be admitted to bail pending the hearing and determination of the extradition proceedings commenced under the Extradition Act Cap 77 laws of Kenya. The applicant, which is the state herein, opposes the grant of bail through an affidavit sworn by number 562 was PC Kennedy Betts. In the oral submissions before the court, the prosecution submits that the respondent presents a significant flight risk and that there are compelling reasons which exist to warrant his continued detention pending the determination of the extradition proceedings. According to the prosecution, the respondent is sought by the UK to answer charges of murder, manslaughter, perverting the course of justice, and fraud by false representation. The prosecution avers that investigations conducted by the requesting states indicate that shortly after the alleged commission of the offences, the respondent departed from the UK for Kenya. It's further alleged that on the 10th of June 2026, the respondent was intercepted at the Namanga one-stop border post while allegedly attempting to leave the Republic of Kenya. The prosecution further relies on the allegations that at the time of his arrest, the respondent was traveling using a temporary travel permit despite being a holder of a Kenyan passport. From the affidavit opposing bond, it has been indicated the respondent has more than one Kenyan passport, being passport number A2558773 in the names of Brian Kiplagat, which was issued on the 5th of December 2016, and number CK84104 in the names of Brian Kiplagat, issued on the 17th of November 2022, and the surrender of the travel documents will not sufficiently eliminate the risk of absconding. The prosecution additionally argues that the respondent has no fixed place of abode within Kenya, and the seriousness of the offences and the evidence contained in the extradition request provide a strong incentive for him to flee the jurisdiction if released on bail. The respondent, through the learned counsels, opposes the application for detention. Counsels submit that the respondent is entitled to bail under Article 49(1)(h) of the Constitution of Kenya. Counsels further argue that the offences in question are bailable, and the prosecution has failed to demonstrate compelling reasons to justify the denial of bond. They further submit that the respondent is a Kenyan citizen, born and raised in Eldoret, has deep family ties within the jurisdiction. The court was informed the respondent's mother and brother attended court and are willing to stand as contact persons and ensure his attendance whenever he is required. It was also argued that the respondent's passport and temporary permits had since been confiscated by the authorities, and consequently the apprehension that he may leave the country is unfounded. Counsels urge the court to find that any concerns regarding the attendance can adequately be addressed through reasonable bond terms, requiring the respondent to report to the police station as frequently as possible. The court has well considered the rival submissions, the affidavit on record opposing bond, and the applicable law. The right to bail is guaranteed under Article 40, subsection 1(h) of the Constitution, which provides that an arrested person has a right to be released on bail or bond on reasonable conditions, pending a charge or trial, unless there are compelling reasons not to be released. Although extradition proceedings are not criminal trials in the ordinary sense, the constitutional principles governing the liberty remain applicable. The burden rests upon the applicant to demonstrate the existence of compelling reasons warranting the denial of bail. The principal ground relied upon by the state for opposing bond is that the respondent is a flight risk. The material placed before the court shows that the respondent is alleged to have departed from the UK shortly after the commission of the offences for which he is now sought. Whether or not that departure ultimately proves to have evidential significance is not for determination at this stage. Equally significant is the deposition that the respondent was arrested while attempting to cross the Namanga border using a temporary permit, notwithstanding he was a holder of Kenyan passports. While the defense admits that both the passport and the temporary permit are presently been confiscated and the travel have been presently confiscated, the confiscation of the travel document does not by itself eliminate the possibility of absconding. Modern modes of unlawful border crossing are not necessarily dependent on possession of travel documents. The court must therefore consider the totality of the circumstances rather than the factor in isolation. The seriousness of the offences for which the extradition is sought is another relevant consideration. The respondent is sought to answer charges which include murder, an offence carrying the gravest penal consequences both under the laws of Kenya and the United Kingdom. The severity of the charges and the potential consequences upon extradition provide an objective incentive to evade the jurisdiction of the court. The court has considered the respondent's personal circumstances. He is a Kenyan citizen with family members present in court, and those ties ordinarily weigh in favor of release. However, family ties, though important, cannot automatically outweigh other objective indicators where the evidence points to a reasonable risk of absconding. Having carefully weighed the competing considerations, I am satisfied that the applicant has demonstrated compelling reasons to warrant denial of bail at this stage. The cumulative effect of the allegations that the respondent left the requesting state immediately after the alleged commission of the offence, was subsequently intercepted while attempting to leave Kenya, and is alleged to possess multiple travel documents, and now faces extradition on extremely serious charges, persuades this court that the risk of absconding is real and cannot adequately be mitigated by bond terms. Learned counsel for the respondent urged the court to consider less restrictive measures in keeping with the dictates of the Constitution, including requiring the respondent to report periodically to a police station instead of remaining in custody. The court has duly considered that submission. While the Constitution enjoins the court to adopt the least restrictive measures where appropriate, such measures must nevertheless be adequate to address the risk sought to be mitigated. In the peculiar circumstances of this case, where the court has found that there exists a real and substantial risk of absconding, periodic reporting requirements or similar conditions will not sufficiently secure the respondent's attendance throughout the extradition proceedings. Such measures will therefore not be adequate in view of the compelling reasons established by the applicant. That said, the court is equally mindful that the respondent enjoys the constitutional right to liberty and that extradition proceedings should not result in prolonged detention without determination. The court is therefore of the view that the least restrictive and proportionate course in the circumstances is that, while not granting bail, but rather to ensure the extradition proceedings are heard and determined on a priority basis. An expeditious hearing will minimize any prejudice to the respondent arising from his continued detention, while at the same time safeguarding the integrity of the extradition process and ensuring his availability should the application ultimately succeed. It is important to emphasize that these findings do not amount to a determination of the respondent's guilt or the merits of the extradition request. Those issues remain to be determined at the subsequent hearing. The present determination is confined solely to whether compelling reasons exist to deny bail pending those proceedings. The respondent's application for release on bail pending the hearing and determination of the extradition proceedings is therefore declined. This matter will be accorded priority, and the parties are directed to comply with all the necessary pre-hearing requirements without delay so as to facilitate the expeditious disposal of the application. In the meantime, the respondent will remain in lawful custody pending the expeditious hearing and determination of the extradition proceedings.
We will be requesting for typed proceedings and we can take directions.
Yes.
Yes.
Your Honor, we request that the respondent is remanded at industrial area pending the hearing and determination of the extradition proceedings. In line with the requirements of Section 9, of the Extradition Commonwealth Countries Act, Cap 77. Yes, Your Honor, we intend to dispose of this matter through submissions. And on our part, we can file in something for 10 days.
Yes.
I don't know why. I don't know whether HB is not sufficient.
No, the Act specifically provides for custody. And Your Honor, we've had an incident where we had a fugitive who escaped from a police station. So, industrial area. Those are my instructions.
Yes.
Your Honor, we would pray that it remains at HB.
No, where a person is remanded in custody pending a determination of a hearing on an application, the police station is not viable. That is usually a temporary measure. But if it's remanded, it has to be at the custodial place, which is industrial area or any other facility, but not the police station. That is not recommended for where a person is now undergoing trial or such an application. Yes, so for the directions, you are agreeable to have the application canvassed by way of submissions. Yes.
Yeah, we can do submissions and then will we be able to highlight?
Yes,
the court?
yes, we can agree on the timelines. I think the state has requested for 14 days. Maybe you can let us know.
21 days.
Sorry?
We can have 21 days. Yeah, so do we put in our reply and then with submissions?
Yes, because I need to, if not file your reply, you can put in the reply together with the submissions to the application. Well, for me to get these timelines properly, let's just agree, for me to get these timelines properly, do you need the 21 days after service of their submissions or from today? Are they running concurrently or each party, they're taking 14 days, then you take 21 days after service?
I noticed that we had not replied to their notice of motion.
Yes.
So would you take 14 days to reply? Then they can do their submissions within that time. Then we have 14 days to reply to.
Yes, maybe council, will I suggest maybe 14 days to reply is too long. Can you take 14 days to reply, then we start having the time for the submissions running from then?
Yes, that's what I'm saying.
You had said 14 days to reply, which is a bit too long, since the respondent is in custody, and I believe you want it to be heard at the expeditiously. So I think for a response, 14 days is too long. So you can have maybe you reply within 7 days, serve your response, then they can have the 14 days to put in their submissions, then you'll have your 14 days to put in the submissions. We have with those timelines.
Your Honor,
Yes?
I'm with the original request from UK.
Have the application, which is dated the 24th of June 2026, canvassed by way of written submissions. We can have the respondent file the response and serve the same within the next 7 days of today's date. The applicant will thereafter have 14 days to put in their submissions and serve upon the respondent, who will have a corresponding 14 days to put in their submissions. So I believe the timelines are taking us to the 4th of August. So the councils can confirm if that is convenient first. The 4th of August for mention, we confirm the submissions have been filed. We can also have them highlighted on that date.
Yes, Your Honor.
Yes. So we'll have the matter mentioned on the 4th of August 2026 to confirm compliance. In the meantime, we'll have the respondent remain remanded at Industrial Area Remand Prison, and we can have the file marked as a safe file. Let it be stored in the safe custody by the court administrator.
We are most privileged.